So I'll introduce myself. My name is Kurt Royce. I'm the founder and CEO of EB-5 Marketplace. Let me introduce our guests today. Robert Devine leads the immigration group at Baker Donaldson, a law firm of about 700 lawyers in over 20 offices. Robert's the author of Immigration Practice, a 1,600-page practical treatise on U.S. immigration law, now in its 15th edition. He was the first person appointed to serve as the chief counsel of USCIS from 2004 to 2006, during which time he also served as acting director. Robert also acted as vice president for the EB-5 industry group IIUSA for 7 years. Good morning, Robert.
Hi.
My next guest is Christian Trianfilis, who leads the Jackson Walker Investment Immigration Practice. He represents foreign nationals and immigrant investors in cross-border and business immigration matters. Christian is experienced in EB-5, E-2, and L-1 visas. Good morning, Christian.
Morning, Kurt.
Our last guest is Sam Newbold. Sam is a member of CSG's Alternative Capital Group and manages the firm's EB-5 practice, representing companies from all over the country, as well as provides counsel on employment-based immigration matters, as well as corporate compliance, best practices. Sam's corporate clientele operates in almost every industry. Morning, Sam.
Hey, thanks, Kurt. Happy to be here.
And Sam, you're in New York or New Jersey?
New York, Times Square.
And Christian, you're in Houston?
Right.
And Robert, are you in Chattanooga?
Today I'm in my house in Naples, Florida.
Great. So before we get started, Sam and I had a few moments to talk about some of the developments related to the EB-5 Regional Center Reauthorization Bill. Sam, could you share some of your thoughts with the audience?
Yeah, sure. So we know that a couple days ago, Senator Schumer pushed language towards Grassley and Leahy's camps for consideration in the reauthorization bill. This is the Nadler language. So this is the more favorable language that people are looking for, the $700,000 and $850,000 investment thresholds for reauthorization. So we know that that language exists and it's been sent over to the Leahy and Grassley camps. But we also know that Leahy and Grassley sort of like the way things are. They're the gatekeepers for this. So no language is going to be pushed through that they don't approve. We know from history that they sort of like their $900,000 and $1.8 million marks. So it remains to be seen whether or not that language sort of gets adopted or not. While that is happening, we have this issue in Ukraine. I think the official position of the United States is that we consider Russia to have now invaded Ukraine. So a lot of the oxygen in the room and Congress is going to be devoted to giving President Biden whatever he needs to manage that situation, whatever immediate appropriations will be needed for that, military appropriations for spending, whatever is needed for that situation over in Ukraine. And that probably means that any kind of real conversation with reauthorization will get punted for some time later in March or maybe early April. So I would expect to see some kind of CR, short-term CR from March 11th, maybe through the end of March, or even for a couple of weeks to give Congress enough time to deal with the situation in Ukraine while everything else is kind of tabled. You know, all of that is sort of speculative.
Sure, Sam, thank you. It's a very fluid situation, and it's nice to have some insight as to what the timing is on this reauthorization. It's also nice to know like kind of what the inner workings of the compromises are of that bill, because all of that is going to affect the timing of a potential new bill. We've got 80,000. I think that's an estimate of how many petitioners have filed under the Regional Center program whose petitions are pending right now. Robert, you seem to take exception to that number.
I guess I had estimated there might be 100,000 people involved, affected, including family members. I didn't think there were that many petitioners, but hey, I don't know.
Man, I'm no expert, so I'm relaying what I've heard. But if your estimate of 100,000 is right, maybe it's 40, 35 to 40,000? Is that what you
I
think?
think
Christian?
those are some of the
Yeah.
numbers I'd heard, more
Yeah.
along the lines of petitions.
Yeah.
Okay. So in our current environments, if you file under a direct program, you could potentially only be facing maybe a few hundred petitions ahead of you. If the regional center program's back, and suddenly the lines change and all those 35 to 40,000 petitions may get in front of you, with potentially the exception of people who filed into an exemplar approved project. So that's the conversation we're going to have today. Robert, I guess the first question I have is, what does expedite mean?
Well, it means that the investor has asked, and this request can only be made by the investor to USCIS because the investor is the filing party. Whoever is selling the investment can provide information to the investor, but the investor is the one making the filing and making the request about their petition. But that request is to say, hey, because of something either about me personally or the thing I'm investing in, this is worthy of expediting, of putting this ahead of other investors in the queue and adjudicating mine first. It doesn't mean that they necessarily hyper speedily actually adjudicate the case. They just assign the case to an adjudicator out of turn and ahead of everybody else who is waiting. The agency likes to have kind of clear guidelines, and they recently restated what those guidelines are. I don't think that the way they restated it was meant to have much of an implication on EB-5 petitions,
Right.
but rather was focused on all of the other petition types and application types that USCIS adjudicates, which is many. EB-5 is a very small component of what USCIS adjudicates, but they did restate it. So the grounds are articulated in a web page that USCIS publishes called How to Make an Expedite Request. And if you just Google USCIS how to make an expedite request, you'll get to that page pretty easily. And the reasons can be for severe financial loss to a company or person, provided that the need for the urgent action is not the result of the petitioner's or the applicant's failure to timely file the request or to respond to something. That's one, and there's some nuances there. Emergencies and humanitarian reasons, and that's more commonly the basis for an expedite. And then U.S. governmental interests. So those identified as urgent by federal agencies, and that's it.
So looking at these 4 questions that we've included in the agenda, 2 of them seem to be fairly straightforward, and I'd like to cover those 2 first. So we mentioned, what does the expedite mean? Robert also alluded to why the investment qualifies or should qualify. Christian, could you pick up on what Robert was saying? Any aspect to what does expedite mean, or what would qualify that you could add to?
Well, I mean, I agree with what Robert was saying. I think expedite gets confused about the actual adjudication of the I-526 petition versus it just getting assigned to the officer in an expedited manner. So when we request an with USCIS, USCIS will come back, they'll indicate that they've received the expedite request. They'll say, give us 14 days, and then they'll make a decision on that request. Now, if they grant the expedite request, that does not mean that the I-526 petition is approved. It means, as Robert mentioned, it's going to get assigned faster than it normally would. Now, typically, I do see expedites approved or adjudicated faster than a normal I-526 petition. So there is a real benefit in that expedite request being granted. That's the I-526 petition that then goes on to the next stage of whether there's an EB-5 visa available to that foreign national or not. Of course, right now, there are no backlogs in EB-5, but when the regional center program comes back, there will be. I typically see I-526 petitions qualifying under the urgent humanitarian reasons. I've made national interest arguments before, although those can be pretty difficult if you don't have clear support from another agency, typically another federal agency. So I do think right now USCIS is looking very heavily at urgent humanitarian needs as reasons for expediting an I-526.
Great. Sam, any thoughts?
Well, yeah, it's expedite request, right? Just as a quick background, you can do an expedite request for any kind of benefit request, petition, or application where premium processing is not available, right? And so the vast majority of expedite requests that USCIS receives pertain to work authorization cards and advance parole. So as Robert said, initially, the attempt by USCIS to sort of clarify some of its criteria, which was revised last month, early in January, I think was primarily aimed at trying to curtail all of the huge volume of expedite requests that they've received because of backlogged EADs and APs, and not so much directly related to EB-5. And I think Christian is correct in that when it comes to IPO, look, when you make an expedite request for other types of cases, whether it's an I-360 for a religious worker, for an EB-1C multinational manager, any kinds of cases where premium processing is not really available, it's really hard to get a hold of someone direct at the field, at the service center to really, push that through. It's a little bit different for EB-5 because IPO has traditionally been pretty good about direct correspondence on cases. They kind of have a standalone office there in DC. So when making the expedite request, the ability to follow up and communicate directly about that case is a little bit better when it comes to IPO. So Christian's right in terms of, you'll get an update typically from IPO about what's going on with that case, whether or not they're going to consider or approve that expedite request, and then it's a matter of waiting for something to come in the mail, hopefully an approval notice. But you don't really get that kind of customer service with other kinds of expedite requests for other benefit categories. So it's nice to have that with IPO. With that, we have a little bit better ability to kind of track what's actually going on with an expedite request when it comes to EB-5 cases versus other types of expedites.
Before we start talking about how it affects petitioners, I thought I would just share some of the projects that we're currently either have expedite processing on or anticipate that it will have it. So hospital innovation. Robert, could you just talk a moment about this project? This is a project that you're involved in that you submitted, I believe, the expedite request on. What about this project do you think makes it potentially suitable for expedite?
Well, we haven't made a request about it because the offering is being finalized at this moment. But it's about to be, subscribed, people filing, making a request, and we're putting together the final package for the request for expedite. But this hospital innovations project is funding for a mental hospital that has a significant component of addiction recovery. And we know that addiction recovery has a strong case for expediting because we have separately submitted expedite requests for EB-5 funding for direct EB-5 petitions after June 30th of 2021, based on or used to fund addiction recovery centers. And USCIS has granted expediting for every one of those investors. So, and we know that the president has, made a very open statement that the federal government is going to do anything it can to support the development of addiction recovery assistance. And so we know that's a strong component. When you add in a mental health facility as part of that investment, then, that's another component. I believe, there's a good chance that it will be expedited because mental health is, is its own emergency and urgent humanitarian situation that has been greatly exacerbated by COVID-19. I mean, we're in a mental health crisis in this country, part of which is reflected in addiction, but there's a much larger but still urgent thing. So the case can be made, and I think it has a good chance of being also expedited.
Right, especially with your previous experience in a similar addiction treatment facility. And Robert, you had mentioned that the expedite application has not been filed. My question is the filing of an I-526 petition by an investor, does that need to be acknowledged as having been received by USCIS? Is that the trigger that allows you to file the expedite, or am I misunderstanding that timing?
Well, I mean, you can include in the package of the I-526 filing a request for evidence and all the supporting reasons. USCIS generally says if you want to expedite something, don't just depend on what's filed in the mailroom with an application or a petition and the fee. You need to do something extra. When it's not EB-5, then you have to call the 800 number or get on the website to this Ask Emma thing and make your case and try to get an adjudicator, get some contractor person to elevate the request to somebody who could actually make that decision and so forth. And it's pretty awkward. So you have to do something more than just include it in your filing, because it takes too long for anybody to ever look at what just gets filed in the regular course of things. So you do something to draw it to immediate attention. With EB-5 cases, as these guys have mentioned, there is an email address that people who filed an EB-5 petition can send to about their case. And so you send that and say, we want expediting to this petition. You need to have the receipt number already, or they have no way of, connecting to what has been done. So as soon as you have a receipt number, then you can say, hey, IPO, email, this petition is expediting here, and attach the same evidence that you probably included in the filing. And then they'll consider it. And then they'll say, as Christian said, we'll get back to you in 12 days or whatever it is. And often they do as quickly as that. Sometimes they don't, and say yes or no. So I'll go ahead and say, I think I may know about the only project that has been actually granted expediting so far in the post-regional center legislation era that we're in, that started June 30th of 2021. And USCIS has said we're expediting. We grant your request for expediting. We will now assign it to an adjudicator. But I haven't seen an adjudication yet. Those grants of expediting started happening basically in December. And now we're 2 or 3 months later and we're still waiting. So it could be any day. And my expectation from previous experiences in the past with expediting is that it should be 3 to 6 months, but we'll just have to see what actually happens.
Right. And I've got a small correction here. Christian Triantfilis, the new young gun who's filed an expedite. You've got an expedite process approval, Christian, I believe, on the Breeze Light project.
Right. We have about 5 of them now. So lots of success on that. But Robert, you weren't far behind on saying that. This is very recent. So I just wanted to mention something that Robert had said. I think, perhaps there was some, not amongst the panelists, but confusion within the industry on how to get an expedite submitted, because we were used to seeing under the regional center model, perhaps a project filing an exemplar or being able to make requests for expedite treatment of their I-526 petitioner / investors, as compared to the direct program where there is, you cannot file an exemplar application on behalf of the project. As Robert described, you have to submit it through the investor's I-526 petition. So there is, under the direct model. So there has been that transition or a different attempt to get expedites granted. Now, talking about Breeze Light, there were hints that the government was giving to us that a project like this would get treated for expedite processing, or investors investing in this project would get approved for expedite processing, because when COVID-19 started, I'm sure amongst the three of us, we were able to advocate for I-526 petitioners who were medical workers to get expedited treatment of their I-526s, regardless of whatever project they had invested in the regional center program, whether it be a big real estate project that had nothing to do with expedite treatment. If we made an argument about that individual combating COVID-19, USCIS treated it very fairly, and for the most part, granted those expedites very quickly. So when Breeze Light came along and said that we're going to be manufacturing medical grade face masks for both the general public and medical workers to combat COVID-19 now and going forward, we felt like we had a very good position to make an argument for expedited treatment of I-526 petitions filed in connection with this project under the urgent humanitarian needs. And USCIS so far has agreed that yes, these should be granted expedited processing.
Yep. And congratulations on that. And Sam, you're involved with, not this one, that's 1215 Molecular Diagnostics. Can you share a little bit of information of why you think this project is applicable to the expedited processing?
Sure. Well, we're submitting the first 526s for this now, so we'll keep you posted on that. But it's similar to Christian's case. You know, testing seems to be where the country is going in terms of preventative steps for COVID transmission. You know, the Omicron variant obviously has run rampant even among vaccinated individuals, and testing seems to be, you know, a logical step as to how we can try to live our lives a little bit more normally, but still take preventative steps to prevent the spread of the virus. And 1215 MD has developed an extremely accurate point of care test that's very affordable, much more accurate than the tests that are currently on the market that you can get from the government, through the Postal Service, or at any sort of pharmacy. And this particular, you know, project speaks to a number of different points, you know, in the expedite criteria, mainly public safety and public health, as well as humanitarian factors as well. In fact, if you go to whitehouse.gov, the president's own website for the White House, there's an entire section of the White House's webpage dedicated to the proliferation of at-home testing and building out testing. You can go to, you know, government websites now and request tests, and they'll be sent to you for free. So it is a top priority of the executive branch to promote testing, more accurate testing, more access to testing.
Can I ask you a question about this? I'm wondering, when you submit an expedite request, how much documentation do you need to file, and what does it typically consist of?
It varies. It depends on what you're at, what sort of criteria you're going after, and whether or not you're going to be relying on, you know, agencies for that request or not. Sometimes you don't really need to supply that much documentation. Sometimes it just sort of speaks to itself, and it's just a matter of putting together a good argument, taking publicly available information and putting that together and saying, hey, look, here it is. And sometimes that's the most obvious type of request requires, you know, less documentation. If it makes sense on its face, then, you know, it's less discretion involved there, right? This is clear and obvious that this deserves this kind of special treatment. Right. So for example, this case, again, along very similar lines to Christian's case, it's the same industry. It's fighting COVID.
Sure.
You know, it has just.
It seems obvious.
It's so obvious, right? That it's something that should qualify.
Now, Christian, your first application you got expedited approval in 2 days after filing, as I recall.
Yes, they did get back to us. USCIS came back to us very quickly on that. Now, that hasn't happened for every request. They might take the full 14 days, but they did open up that first request. And this is, much because we have the benefit under the EB-5 program to communicate directly with the IPO via their email address. And they did come back within 2 days and said that this request has been granted.
Okay, so then the next question I have here is, how does an expedite affect petitioners? And then we'll finish with, what would be its impact if the regional center program was to be reauthorized? So if we could start here, Sam, how does it affect petitioners, these expedites?
Well, the quicker you can speed up the I-526 process, keeping in mind, historically, that's been a 2 to 3 year wait. And you got no benefits as a result of just filing a 526. So you need an approved 526 in order to file an adjustment of status or pursue an immigrant visa abroad. So the faster you can speed up getting the petition approved, the quicker the investor can get to the point of actually applying for their green card, assuming that their priority date is current in the visa bulletin. So right now, while we have, for direct EB-5s current across the board, if you had an approved I-526 petition today, you were in status in the US, you could file an adjustment of status. If you were abroad, then you'd be able to proceed with an immigrant visa as long as it remains current, up until the date you actually get your visa in hand at the consulate. So for many people, it speeds up the process that was traditionally long. And that's been one of the gripes and concerns about EB-5, is that, it can be a great benefit to get, but it takes a while to get there. So it speeds up the process in which you can actually get your conditional green card.
Right. Christian and Robert, any additional thoughts to how it might affect petitioners? I know it's pretty straightforward.
Well, I mean, I think when you add in the component of what happens if the regional center program gets brought back in, it gets a bit more complicated.
Sure, a lot more complicated, sure.
Yeah, so particularly if an investor was born in mainland China, and if they're behind tens of thousands of other mainland Chinese investors waiting for a visa number, and if they have a child who might become 21 while waiting for that visa number, it actually might be against the interest of the investor to get expediting because of the Child Status Protection Act. This would only apply to somebody who would be waiting for a visa number after an I-526 approval, and whose child, would be approaching age 21 during that period of time, because the investor, the child's age is essentially frozen during the period that the I-526 is pending. And then,
Robert, can I do this for a moment? Because what you're pointing out, I think it's important, and I think it has a place, but I'd rather cover the bigger aspect of this, and then maybe come back to this nuanced issue.
Okay.
Because,
well, it's actually a pretty small deal. It's a non-existent issue right now until the regional center law gets enacted. So while we're still in, direct only, then there's no waiting list for anybody, visa number. So there's no reason for any investor not to want to get expedited. So getting that I-526 petition approved puts you ahead of everybody else in actually now moving ahead and getting the immigrant visa. And if somehow there was so much demand pouring into the system that it could, create an excess demand for visa numbers for a particular country hitting the per country limit of 700-ish per year, then having gotten through the gate with an expedited petition to lap up one of those visa numbers before everybody else can get their 526 adjudicated is hugely, even more advantageous.
Right. Maybe we should continue on with China. Christian, do you feel comfortable talking a little bit about the implications that might affect the Chinese here? I know it's complicated. I know it's a lot of guessing.
Well, sure. I mean, I think Robert was building up to it. Let me just first say, one of the implications of the regional center program coming back is maybe that reallocation of USCIS resources as well. Right now, with direct being the only game in town, we could see, I don't know that we will, and 3 to 6 months was stated earlier as how long it might take an expedite to take, but we could see exceptionally fast adjudications of I-526s, because it would seem to be that there are not as many I-526s to cover right now as there typically would be while regional center remains on hold. Okay, so talking about China, yeah, when the regional center program comes back, they are going to be subject to their very long backlog again, and that will be all I-526s, regardless of whether they filed under the direct or regional center model. The idea would be to see if an I-526 filed by a mainland-born Chinese national could be assigned to an officer and adjudicated and getting the visa, the immigrant visa, prior to the backlog being reinstated when the regional center program comes back. That's how someone from China could really take advantage of being in an expedited project.
Right. Sam, you can understand why I chose China, right? It's the extreme case. Can you continue to talk a little bit about the impact of the regional center program getting reauthorized, and how might the expedite affect that eventuality?
Yeah, well, it gets pretty complicated pretty quickly when you start going down that rabbit hole of how it applies across the board to mainland China. Robert's right. I mean, you have the considerations for dependent children, and the fact that if you have a 526 that takes 3 years, that's 3 years that you can subtract from the child's age for purposes of trying to at least keep their age frozen. I know that there's 2 buckets, or there were 2 buckets prior to June 30th that USCIS was using, treating cases that were non-mainland born China, and then mainland born China, they had processing times basically that they were applying to that. And if you went to their website and you looked at 526 processing times, they basically had, a mainland China bucket and everybody else bucket. And we know from policy that they've basically been keeping those cases at bay, which is nice. But with an expedite, right, you're kind of like telling them to hurry up and adjudicate the case, which could potentially negatively impact CISPA benefits, as Robert was saying.
Okay.
The real question is just right now is just, does it make sense for a Chinese investor to jump on now to buy a direct investment and file a petition and ask for expediting to try to get through this, shoot the gap and get through and get a visa number before Congress passes something that opens the floodgates again for the regional center program, and all those other Chinese investors get put back in front of that investor in the queue for visa numbers?
And it doesn't get any easier with the decision tree, because shooting the gap now also comes at basically half price, right?
Yeah.
So when regional center reauthorization hits, we know it's going to be more expensive. We don't know what those final numbers are going to be, but let's just say it returns to what it was with the modernization rules, right? $900,000. Maybe the project wouldn't even qualify under those revised TEA rules, and now it's 1.8 million. So there's a lot to think about, another factor that makes it worth pursuing, especially if it seems like it could be half price, for the time being. So
Kurt, this is why when I did an alert about this, when it first came up and there was no waiting, no cutoff date for China anymore under the direct program, I basically said, the person who would do this is a Chinese person who's got a lot of money and who can afford to just burn $500,000 or put that on hold. I'm not saying it's burnt forever, but just,
make an investment and
take a shot at it. And if it doesn't work, then still look at doing, another investment later on that might be on a longer track.
Do you expect that USCIS will grant a certain period of time before the regional center program gets reauthorized, or does it happen on the day of the bill being passed? My question is, does the directs continue to be the only game in town, or does it end at that moment?
Well, it depends on what the legislation that Congress passes says, but
Right.
if that legislation is going to benefit existing investors under the regional center program who don't have to refile somehow or whatever, then I would imagine that those people would be instantly back in the queue and ahead of everybody. I'm not sure that anybody talked about this, but if you get expedited today, if you get granted expediting of a direct petition today, let's say you're not Chinese, you get granted that expediting, and then all of a sudden in March, Congress passes a law that says, okay, all these other people are back in the queue and ahead of the direct filers in line. I'm not sure that puts anybody back in front of somebody who got expedited. I believe that expediting will survive the restoration of all those regional center investors.
Yeah.
So I think that expediting will stick. And it would be, so for anybody who's not mainland Chinese, it's hard to see why you wouldn't jump on doing this now if you can.
Let's just say for purposes of conversation, it is punted until the end of March. Even, that's not enough time by and large, right? You're not going to get a green card, even with an approved 526 today that was expedited. You're not going to get a green card by the end of March.
Well, look, there's no guarantee that the regional center legislation will get renewed.
It's true. Yeah.
And so a Chinese investor who just says, I'm willing to gamble on trying to get through the gap before they get around to it, it might not happen for you, or it might not happen ever. And I'm willing to take that chance now to get in at 500,000 and with a chance to get really speedy adjudication and get that green card in my hand and get my kid into the United States, whatever.
Yeah, it's true. Like look at what we have to work with in terms of history, Robert and Christian. When is the last time that Congress ever really came through?
Well,
it was like never really.
Right? We also have to look at what the extension or renewal would look like if it does, occur. Is it going to be long term? Is it going to be short term again? Could this happen again? We'll hopefully we know soon. But for a Chinese investor, they might be willing now to kind of gamble on the ability to get an expedite approved and have visa numbers available to them now, or perhaps in the future if the situation happens again.
Terrific, guys. I've got a few questions here. Let's see. Robert, why USCIS has been so inefficient since July of 2021? They've been processing only a few applications each month. On that?
My guess, and I've heard some things, but I can't know them unless you're inside of there, and I'm not. My guess is that with all of the backlogs in so many other areas and general employment-based categories, that the agency has siphoned off EB-5 adjudicators who, are some of their most educated, maybe smartest people, to some of these other pipelines that they feel very desperate to get adjudicated. And, they've been doing a lot of things lately to try to facilitate giving out all the visa numbers in the other employment-based categories during this fiscal year and during the previous fiscal year. And so I wouldn't be surprised if they've siphoned off a lot of the capability to other streams of work.
Right. Yeah, we've speculated in our roundtable group about maybe Afghan refugees are getting some attention.
And that said, July 2021. I mean, I think all seen inefficiencies since March 2020. So across USCIS. So that's just the new normal, unfortunately. Yeah,
and there's been layoffs. I know at the State Department level, there's been tremendous layoffs. Just talking with different people inside the State Department, also at CBP, they're having issues. Like, you can't hire enough people at CBP, but at the same time, State Department has been laying off people at local consulates as well, while consulates have been closed. So, like, it's all a fluid situation, but I think you're right. It's not just a June 2021 issue. It's just been percolating for some time.
How long will an expedite take to be approved? I think the answer is we don't know, but you're obviously going to be faster than anyone else.
Yeah,
you
my
know,
guess is 2 to 6 months.
2 to
Yeah, I
6
would
months.
agree. I would agree.
Okay.
Yeah, technically anything quicker than posted processing times would be expedited. But I think you're both right. I think, 60 to 180 days is probably a good way to temper expectations.
Okay. What about India? And obviously India falls into the bucket of just about everybody, right? There's no difference between India and anywhere else at this point.
Well, there's one twist to that, I would say, just to be super candid, as I always have tried to be about this whole visa number issue, since I sort of blew the doors off the issue about China in 2015. But if USCIS suddenly applied a lot of resources to adjudicating I-526s, that could actually create a waiting list, an active waiting list and imposition of priority dates for India-born investors, because there are more than 300 in the queue, right? I mean, of regional center-based investors, there were far more than 300 in the queue waiting for adjudication. It's the only reason that those investors didn't start having to wait behind each other is because USCIS was not adjudicating 300 of them in a year. That's the reason.
Yeah.
So if US speeded up, then there could be a wait. Otherwise, the backlog is essentially hidden in the delays of I-526 adjudication.
Do you guys think that, let's say that, regional center reauthorization happens and USCIS starts to wake up, what are we going to see? Are we going to see a really long delay for cases to start being, decided and adjudicated? If we think that staff has been reassigned from IPO to other places, then they have to reassign people back to IPO, and then, I can't see it just, the light went back on, all of a sudden we're going to start processing cases again. There's going to be a huge delay, right?
Nothing happens fast.
And so, Sam, I guess that speaks to, for an Indian national filing under Expedite, does that speak to their ability to get an I-526 approval faster than the many I-526s already filed?
Well, this gets right to what was happening before the regulations took effect in 2019. There was one project that was getting expedited. Everybody knew about it. It was that equestrian thing. Why that was expedited, I'll never fully understand, but it did. And people from India were very sensibly piling into that project to get through the gate,
right?
And shoot the gap.
They were able to do it,
and get ahead, get the visa number, and be gone before all those other people got adjudicated and actually created a waiting list for visa numbers. And that could easily happen again. I mean, that rationale is just as meaningful now for investing in an expedited project to get ahead of everybody else from India.
And just one final note on that, we know that October 1st, starts the clock again, for the fiscal year and visa availability numbers. If you're applying for an expedited project now, most likely, if the expedite is approved, you get your case approved and you get, your adjustment of status, submitted, or your immigrant visa, application underway, and you might have good timing with respect to the bulk of visa numbers being the most available come October 1st, right? So the timing is pretty good right now.
Well, you still might not get an actual visa if you do adjustment of status. You may not get your actual visa assigned through the approval of adjustment of status until fiscal year 2023. Or
right.
Fiscal year 2024 is the year in which the fiscal year ends. But I don't see USCIS cranking up fast enough to make that a problem.
Yeah, I agree.
Okay, guys, listen, I've got some questions that I'll send to you guys and ask if you want to respond to any of them by email. I know we got some pressing, that Robert especially has some very pressing issues. So it was great. It really, I think you guys really shed a lot of light on the situation with expedites, and I'm sure there'll be more questions coming in, and I will forward them to our group and get answers to all the questions that we get. Thank you, guys. Thanks for joining us this morning.
Thank you.
All right. Thank you.
Thanks, everyone. Take care.
Bye, guys.